Been talking recently about what I call the collision of rights here on the program. And frequently we're being told that one set of rights now trumps another set of rights, which is a little different because it used to be that rights were exercised largely against government. In other words, there were limits put on government by our Constitution and the Bill of Rights. But lately we have a whole bunch of new rights that seem to be created, and they're challenging the rights other people had under the old rights without bothering to tell them, by the way, that those old rights have been superseded, or at least they find out in some rather unusual ways. Let's talk about one of those. Welcome back to Steel on Steel. John Leffler here with you. Recently in the state of Minnesota, the Virginia Public School District, which is just about 60 miles north of Duluth, opened its school's locker rooms, showers, and restrooms to the opposite sex. You know, we have this whole issue of ongoing gender identity, after the U.S. Departments of Education and Justice threatened to remove federal education funding through a directive under Title IX that it said it was just trying to enforce, which turns out not to be true. Now, imagine your surprise when your daughter suddenly discovers that a male student has begun using the ladies' locker room in gym. And that is being challenged in a lawsuit right now. The Alliance Defense Fund is doing that. Matt Sharp is a legal counsel with the ADF. He's worked on important cases advocating religious freedom for elementary students, things such as allowing a religious song to be sung at a school talent show, allowing a student to be reinstated to the National Honor Society after the school denied credit for church-based community service, and so on and so forth. This is, of course, part of the ongoing culture wars, Matt. You know, you and I both know that. What I've noticed is in these ongoing culture wars is they're just sort of dumped on us, and then we're all expected to honor them, or we're called nasty names if we don't. That seems to be the pattern.
Absolutely. And in fact, we saw that play out in this Minnesota situation. There was no notice given to parents, no notice given to students that the school was going to change its policy and begin allowing a male into the female locker rooms. The girls just walked in one day and surprised, there's one of their male classmates sharing the facilities with them. So this is on a small scale what we're seeing across the country, where the federal government and the Department of Education is issuing this national mandate telling every school in the country that it has to allow boys into girls' locker rooms and restrooms without any input from parents and students that are impacted by this.
Now, are they threatening them with legal action or with just withholding of funds? Because that's typically the way the Department of Education acts towards school districts, is they dangle the golden carrot, as I've said.
That's correct, is that they're threatening to take away all of their federal funding. This is funding for things like free and reduced lunch programs from kids from low-income families, special education programs. All of those would be stripped of all federal funding, devastating any local school district if they don't comply with this mandate from the Department of Education.
Okay, now they're doing this under Title IX, and for people who don't know that, this is a law that goes back to 1972, which at the time, the purpose of this clause was to protect women from various forms of discrimination, and it prohibits schools from discriminating on the basis of sex. And both the Department of Education and the DOJ, the Department of Justice, are claiming that Title IX's statutes state that a school receiving federal funds can provide separate toilet, locker room, and shower facilities on the basis of sex without incurring that. So what's the problem here?
Well, there was no problem until the Obama administration manufactured one. For over 40 years, everyone has understood that under Title IX, schools can provide separate locker rooms, restrooms, dormitories, etc., on the basis of sex while fully complying with Title IX. In fact, this exact issue was debated during the discussions over Title IX, with some of the senators saying, well, if we've got this equal opportunity and equal access between men and women, does this mean we can't have separate sports teams and dormitories? And the sponsor said, of course not. And so they put it into Title IX. Several courts over the years have interpreted it that way, but it's only been in the past couple of years as the Obama administration has tried to rewrite what Title IX says, changing the word sex to now mean gender identity so that it can force its agenda on every school in the country. It's only because of those efforts by the administration that we're now getting this confusion over what Title IX means. But I think as courts look at this issue, they're going to see there is no doubt what the drafters of the law intended and how it's been consistently interpreted over the past 40 years.
Now, the language of the law hasn't been changed. What we're talking about here is what, administrative interpretation of the law or writing of regulations pursuant to that?
Not even that. What
the
Obama administration did was just send a letter. They didn't write a new regulation. They didn't issue a formal document. It was just a guidance letter that's non-binding, that has no legal force and effect of law, and they use that to essentially rewrite the law. But like we discussed earlier, they are using that threat of funding to enforce their radical new interpretation. But one of the main points being brought up both in our lawsuit in Minnesota and several of the other ones is that they don't have the authority to do this. If you want to change a law's meaning, there's a proper process to go through. And the administration completely ignored all of that because they knew that there was no chance they could go through that process and get their preferred outcome. So they ignored the law, ignored the procedures so that they can force their agenda on every school in the country.
Yeah, that's been going on in the Obama administration anyway, is the end running of the Constitution, the end running of the law using either executive fiat, which we call executive orders, or presidential directives, or changing of regulations, which theoretically interpret laws. And you see a lot of abuse of that, say, in the Environmental Protection Agency and other agencies.
That's correct. And one of the big problems that we are seeing that courts are starting to address is that the administration has done this runaround of the proper procedures time and time and time again. And courts have been waving that away and say, well, it's all right, we'll still give deference to this new interpretation. And so one of the bases being challenged is no, courts, you can't give deference when they don't follow the proper procedure. You can't give any weight to this and authority for them to run around our constitutional rights and run around the procedures in place. So I think it's going to be one of the big arguments used to restrain the administration from doing this further.
Is it my imagination or not, Matt, as I look at this, that I'm calling this right trumping? We seem to be in a battle of rights now, pitting people against each other rather than the rights of people against governmental-run organizations. Originally, the Bill of Rights was a limitation on government. It didn't put too much limitations on each other. And now it's a game of right trumping and what you can get out of the judicial system or something like that. That's what I'm seeing happen. This is a totally new playing field.
Yeah, and you look at all of this battle over restrooms and locker rooms. This ought to be a no-brainer, that it is meant to ensure that local schools can set their own policy, to decide what's best for their students, to follow the right of privacy that students have by maintaining separate locker rooms and restrooms. And so it ought to have always been, and continues to be, the right of privacy of students versus whatever schools must provide. But as you said, it's now turning into the demands of a student struggling with gender identity issues to use whatever bathroom he or she chooses versus the rights of other students to have private facilities when changing and using the restroom. And the thing is, schools have been accommodating this for years. They've allowed transgender students to access changing rooms and other single stall facilities where they can go and have a private place to change and use the restroom without compromising the privacy rights of everyone else. So this really ought to be a very easy issue. And again, the only confusion is by the Obama administration enforcing its interpretation on local schools.
Yeah, because if I'm going to use a locker room, I go to the gym, I have a certain expectation when I'm there that when I undress, only X number of people are going to see me. It's almost like a social contract type of thing. And here they're saying one group of people's rights don't apply while a very, very small minority of rights does apply, and then they try to force it. And obviously they know this is not going to go without challenge as well. You know that, and I know that.
Yeah, that's absolutely right. And what's really, I think, sad in all of this is the students that are impacted by this and how they're being ignored. We've been talking with parents and students that have been through intense times of sexual abuse in their lives. And so we've got these girls that are saying, I don't want to walk out of a bathroom stall and see a boy standing there. That's traumatic to me. That's a trigger event to me. The bathroom's supposed to be a private, safe place. I've got a certain expectation of privacy when I use that, and that's being ignored. Their voices, the impact on this is being completely trampled on by the groups and by the Obama administration as they're pushing this. We're talking about up to 1 out of 10 kids that have suffered some form of sexual abuse by the age of 18. Where are their rights? Where are their needs being considered in all of this? I think they're being ignored because there is a larger agenda that is being pushed by the Obama administration.
Yeah. All right, we'll follow this case. This is going to be interesting because it will set precedent, I think, around the country. But it's not just this issue. There are a whole series of issues that people are having things rammed down their throats. And ironically, that's part of the anger that you're seeing in this electoral process we're going through right now. I think after, for me, it's after about 50 years of this, people are saying, okay, that's it. That's enough. We've played this game. We were very, very patient, but we're not going to be patient anymore, and so it should be interesting. All right, your website, adflegal.org. Any closing thoughts?
Yeah, I would encourage people to also visit safebathrooms.org. It's a website we've set up specifically on these issues, provide updates about our cases, and even advice for local school boards that are grappling with this issue, and a model policy that they can adopt that protects every student's rights while ensuring that bathrooms, locker rooms, and others remain a safe private place for students and for boys and girls at their schools.
All right, safebathrooms.org, Matt Sharp, legal counsel with Alliance Defending Freedom. So hopefully this will be successful, but we'll see where it goes.
All right, thank you so much.
Well, that ends our legal beagle status for the show today. Coming up in the next hour of the show, how's the